Welcome, everyone, to VACEP Presents, our online training series from the Virginia College of Emergency Physicians. My name is Jeff Kelly. While I'm not an ER doctor, I do handle communications for Virginia ACEP. Today, we bring you When the Lawyer Calls and what every emergency physician and general physician should know about subpoenas, testimony, and the legal process. This is a general overview of what you need to know if you're called by the court to serve as either a fact witness in a case you were involved in, or as an expert witness to provide insights on cases where you had no hand. First, our speakers. Sharif Gray is a trial attorney at Broughton Injury Law in Richmond. He's tried cases as a U.S. Army JAG officer and as a drug and vice prosecutor, served as a federal judicial law clerk at a trial court, and now takes cases to trial as a personal injury attorney. He graduated as valedictorian and distinguished military graduate from the Virginia Military Institute and received his law degree from the University of Virginia. Dr. Jesse Spangler is president of the Virginia College of Emergency Physicians and practices emergency medicine full-time at VCU Health in Richmond. While caring for patients in the ED, he also teaches emergency medicine to medical students and resident physicians. Before we get into it, I'd love to turn it to Dr. Spangler to give us some thoughts on why you and other Virginia ACEP leaders thought this would be a topic of interest to your own colleagues in emergency medicine as well as the House of Medicine.
When you do residency, you don't learn a lot about this whole process. So it doesn't take long for you to get a subpoena after you start practicing medicine. It can be kind of stressful to know, why did I get this? What is a subpoena? What does it mean? A lot of us go to our colleagues and ask, what do I have to do with this? And then we're asking our other doctor friends legal advice on what do I do with a subpoena? How do I respond to it? And it's hard to get a straight answer. We go to social media, we go to the internet, sometimes we go to the hospital lawyers, but just a lot of us don't know what to do when we're asked to give testimony in a case, either as a fact witness or, in a criminal case. So I'd like to get into these topics with Sharif and see, what to do. Can we get paid for our time? What can I say? We have HIPAA ingrained into us throughout training, and then we have to do annual HIPAA training every year, to respect patient privacy. So when we receive these, what can we even discuss with the lawyer? What can we discuss in court? And then what do we do if we have questions about what we can say in court and our lawyer's not there?
Great. Well, that's why we've got Sharif with us today. So, Sharif, set the stage for us, and let's start by just defining what a subpoena is, right? We got to kind of start at the beginning, particularly for maybe residents who are just getting into this, and this is a whole new world. Walk us through what this means and why it matters, and why we need
Yeah,
someone like an attorney on our side.
when you get into litigation, which means that a lawsuit has been filed in a court, at that point, lawyers can then issue subpoenas. So there's two different types of subpoenas. There are subpoenas that can command someone to come to court or come to a hearing to include a deposition to actually testify. And there are subpoenas that can command the production of documents or records. And doctors, I believe, are flooded with both. I would like to think that more often than not, they're probably receiving the subpoenas requesting records. But then, of course, they're also receiving the subpoena that's asking them to show up and actually give testimony as well. So they happen in every case. Both sides will issue them. Oftentimes, it's actually not the plaintiff's lawyer who's issuing subpoenas. It's typically the defense lawyer, and we can get into that if needed. But they're a real thing. They're on this fancy official looking form. A sheriff drops it off of your office. It's definitely, if you're not used to it, it's certainly not something that's fun. So happy to dig in. Like, what do you do when you get something like this? What does it mean? And I mean, yes, it is an order from the court. Like, it is something that you have to follow, but it's not nearly as scary as you might first think.
Yeah, the sheriff shows up at your job and asks who you are and says, you've been I don't know, here's your subpoena. And then your first instinct is, great, I'm sued and I'm gonna lose lose everything. And then you open it up and you're just asked to be a witness. So there's some fear that goes along with it the first few times. And now, it's happened enough times now I know what to do. But so we get this, we wonder what we do next. What do we do next, Sharif? What's the best thing for us to do when we get a subpoena?
My first recommendation whenever someone receives a subpoena is just to pick up the phone. And I know, Dr. Spangler, you and I spoke about this the other day, but I mean, communication is everything. What I have found oftentimes is that our office, for example, we don't just send subpoenas, right? Like in the perfect world, we try and talk to the doctor. We say, hey, are you available on such and such date? Can we accommodate your schedule? All that. Now, granted, our firm, I'm sure, does things sometimes differently than other firms, but subpoena is kind of a last resort. Or it's just because the lawyer didn't do wasn't willing for whatever reason to try and arrange things outside of a subpoena, right? And sometimes people even want subpoenas, and we can get into that too. But a real quick teaser on that is, for example, if someone's in the mental health profession, right, and they're being asked to testify or provide records as to mental health, well, they don't want, I mean, they've got their professional obligations. The last thing they want to do is voluntarily give up that information. So they want a subpoena. They want a court order that says, hey, you have to provide this information. So at least now they're covered. When someone comes under your care, right? Like you want to give them the best possible treatment you can to set them up for success once they leave you, right? With us, we're trying to get the best possible result to recognize what's been taken from the client, right? The loss of their health, the loss of their quality of life. And we need your help to do that. So in many respects, we're on the same page. I think oftentimes there's a disconnect between the legal and the medical community. One for medical malpractice stuff, which I understand. Our firm actually doesn't handle those types of cases. And then two, we speak different languages. But the more communication, frankly, like everything in life, the better.
In the cases I've had, one of my had they just needed somebody to basically read the chart. I didn't realize that in Virginia, like to enter some of the evidence into the court case, the doctor has to somehow be involved. Like you can't just take my chart and just use it, I guess.
Hmm.
And that's pretty easy. And like for that one, when I called the lawyer up to like, yeah, we can set up a deposition. This doesn't have to be done in court. I'm like, great. Like I don't want to waste all, like I hate being bored. I would hate to go sit in court all day just to read my chart. So we could just set up some video deposition beforehand, and that worked out. That ended up getting canceled. Every case I've agreed to go to has ended up getting canceled. Um, and then another one, I called the lawyer up, and they didn't need me. They needed a toxicologist. It was another, like carbon monoxide, I'd say would fall under toxicology, but they needed somebody to help them interpret labs that were done. And, I think somebody was altered or something, but, a phone call just resolved it. And they're like, oh, you don't have to show up anymore. I was like, oh, can you just email that so it's in writing? All right. So I guess I'm not showing up to the subpoena. Like, but it was resolved with a phone call to the law office, and it
I,
seemed like it was just the quickest way to resolve this for everybody.
I think,
I think that's the best practice.
yeah. But before I move on to the different types we've talked a lot about fact witness. We can talk about expert witness in a little bit, but I would love to hear, where does HIPAA come into play in all this, right? Can you review the patient chart? What can you say? Does the patient have to provide consent? So can you talk a little about the line of patient privacy versus legal requirements?
Well,
Yeah, so
I'll start with how I approach these ones because I didn't know
Yeah.
how much I could say. Is that I
Yeah.
call them back and everything is very general at first because I didn't know what I could say about the case. It's like, oh, you're subpoenaing me for this. Well, in these certain situations, you might want a toxicologist. And then uh, that's just how I approach the beginning. I'll let Sharif say, the what to when you can talk about the case and when you can review the chart.
yeah, so when in doubt, ask for the release. So almost every law firm who's doing injury type work will get a release from the client to get records, bills, to talk about that type of information with providers. So if there's any concern whatsoever, like just say, hey, I get it. I can only share so much, but if you could get a release that authorizes me to speak, were fantastic. And hopefully that release will be coming to you very, very shortly. Right. So I would recommend that approach. First off, just to know that, hey, you're covered. You've got the release. That I would probably recommend that versus unless you already have permission from the client or in some other shape or form, or unless a judge is ordering you, right? Like I would make sure that you're covered. Now, one quick thing before we move off for this topic, I get this a lot. What you said, Jesse, about like records and just can't you just look at my records? Can't you just put that in as evidence? We can't. And life would be much simpler, probably if we could, but there are reasons why we can't. It's hearsay. Now, there are exceptions, and that's another hour-long talk in and of itself. But a medical record is an out-of-court statement made for the truth of the matter, um, by a person who is not subject to cross-examination. And so to be able to just put a medical record into a courtroom with no way to test its veracity or explore what things mean or what things may be missing is leads to unreliability. And so because of that, medical records, and not just medical records, any document, for the most part, is considered hearsay unless it meets an exception. So we are not allowed as attorneys to say, well, here are the medical records, judge. Just throw them in. In fact, in the vast majority of cases that we end up trying, there are no medical records that are introduced in evidence because they're just not allowed.
So Sharif, as we've talked about what to do when you first receive the subpoena, but I want to go over like what the playbook is for the next steps. When I call, I've got the consent to talk about the patient's case. I've discussed things with my hospital's, legal team, and then I'm ready to talk to the lawyer. What can I ask for? Can I ask to do a deposition instead of going to the actual court date? When is that possible? Can I ask for reimbursement? If so, what's the best way to go about that? Um, what do we do next?
So, starting off with the most important part of that is yes, you're professionals. When your time is being used, you can charge for your time. In terms of what the rate is, I would consult with whatever group you're a part of and see if there's a rate that you are expected to charge. And if not, then I would talk to colleagues who do this type of work in your practice to see what your fee schedule should look like. Now, in terms of what's next, it's a hard question to answer generally because it all depends on what your role in the case is. But let's take, for example, that you are a physician who treated someone who was hurt in a car crash. And chances are, let's say that lawyer wants you for testimony at trial to talk about your treatment of that patient. And so there's a million things, of course, that happen during the litigation process. And as everyone knows, the vast majority of cases ultimately do not find their way into a courtroom. They settle. So chances are very, very good that one can say, "Hey, lawyer, I get it. I would love to help, but that day, your trial day, doesn't fit with my calendar. Is there anything else we can do to accommodate me participating and assisting the patient in this case, that doesn't interfere with A, B, and C?" And what options does a lawyer have then? There are options to potentially move the date. There are options to potentially take testimony out of order. There are options to maybe even take that testimony by way of deposition prior to the actual date. There are different rules that can come into play, but also lawyers can also. I've done this in cases. Hey, our doctors, when a case gets continued, for example, our doctor that we had hired and we'd subpoenaed is no longer available for this court date. Hey, defense lawyer, would you agree or consent to us being able to do a deposition in advance at their office that's video recorded or remotely, right? And we can just play that during the trial. 99% of the time, you're going to get a yes. So, depending on kind of what your role is in the case dictates what's next.
A lot of these things get canceled like right before the trial, like days before it seems like. Um, can we still request reimbursement for the time that we set aside? Most of us have to request the day off work, get childcare, all this stuff. Is it acceptable to ask to bill for that?
Yes, and it's done all the time. In fact, you'll often see in fee schedules, it will say that cancellation needs to be so many days in advance to for there not to be a fee. And the justification is exactly that. It's we've taken measures to make sure you're available that day, and that meant canceling patient appointments or moving things around, which comes at a cost, right? And I would always recommend, I mean, having a fee schedule and making that very
All
clear
right.
at the beginning that
Okay.
once you're brought into a case, hey, here's my CV. here's my fee schedule. And so it's all known and make sure the conditions are fair, very clear and laid out, and you'll get paid. And if you don't get paid, then go talk to a breach of contract lawyer. I recognize that it's daunting. I recognize that nobody wants to be a part of it. But just kind of circling back to where we started, if the communication is there, chances are it's all going to work out, and it'll be a lot easier
Yeah.
than just putting it off.
Now, one thing I kind of want to transition here. One thing that comes up is when do I become an expert witness? What are the additional considerations for that? So say I get this subpoena, but I'm being asked questions either in the deposition, beforehand, at the trial that seem like there's something that an expert witness should answer. What do I do, and how do I know when that line is crossed?
When we are designating an expert, there are specific requirements that us as lawyers have to meet. We have to submit something called an expert designation that outlines who this expert is, what their background is, what their opinions are, what was based off of their opinions. And I'm sure I might be missing a couple things. Whereas in a fact witness, not an expert witness, you don't have to do any of that because they're just going to talk about what they did or what they saw, right? What they observed. So 9 times out of 10, I would argue 99 out of 100 times, you know if you're an expert witness because the lawyer says, we are retaining you to be an expert witness in this case. But ultimately the difference between an expert and a fact witness, I think the easiest way to think about it is a fact witness is somebody who sees something and then they testify about it, right? They have firsthand knowledge. They did something, saw something, right? An expert witness is somebody who will review materials, whether they had any firsthand involvement at all, and then come up with an opinion based on their training and experience, and then share that opinion with the fact finder, be it the court or the jury. Now,
Well, what would a question like, you saw this patient in the ER at a motor vehicle collision, they hit their head, you diagnosed them with you know, a headache or a concussion, and now they're having headaches for the next few months. Do you think that this motor vehicle collision is the cause of their headaches that has been keeping them out of the work for the next 3 months? And y- you know, at that point, it feels like an expert witness, like as the ER doc that saw them on that day, I don't know if their headache is caused by that. I didn't have this case. This is just the first thing that popped into my head. But that's it's a it's a difficult question of when you become the expert witness in that case.
I would argue that that type of opinion is expert witness testimony
Okay.
because
That's
it
what
is
it feels like to me, but I wouldn't know
right.
in the moment. Like I could say, I don't know. Like that would be my answer. I don't know. Like I
Right.
can't make
And
that
then if the
determination.
lawyer to reframe the question and say, okay, well, doctor, well, based on your years of training and experience, is such and such consistent with this? Yes, right. That sounds like expert testimony to me. And
Okay.
what you'll see a lot, and I'm sure at ER doctors, what they'll experience a lot is they will be asked to do both. They'll be retained as both a fact and expert witness. And we do this all the time. Why? It's one, you kill two birds with one stone, right? We're getting the actual individual who did the treatment and can talk about what they did, what they didn't do, what they saw, how the plaintiff or the client patient reacted and what their demeanor was and all that. And then two, we're able to draw on that experts or that doctor's training and experience. Hey, is this consistent with what you see in car crashes? Is this consistent with the type of procedure that you did? Is that break consistent with a fall, based on what you know about this case, right? And so oftentimes if you're testifying, chances are you're going to be an expert witness and maybe also a fact witness.
Okay. And if we're going to be an expert witness, that would be decided beforehand, correct? Like
Absolutely.
before, okay. So it's
Yeah.
not sprung on us because there are additional ethical considerations, as an expert witness, I feel like, the American College of Emergency Physicians has ethical standards for expert testimony. If you say something is a standard of care and it's not the standard of care, there can be ramifications for that. And I'm sure there's other legal considerations when providing expert witness testimony. Can you comment on what we should do to prepare if we're thinking of also providing expert witness testimony, especially for the first time?
Expert witnesses, I mean, there are physicians who all they do is provide expert testimony, right? Like so, and that's a different world. And I recognize that's not really our audience today. Our
Yeah.
audience is doctors who find themselves in the role of now becoming an expert witness. So probably the easiest thing to do is to make sure that the left and right limits are clear and understood. So, as I mentioned a few minutes ago, whenever an attorney is trying to bring and use an expert witness in a case, that expert's opinion and the basis of their opinion has to be designated formally, at least in Virginia. And so during that process, they can narrow down this expert is going to talk about these five things based on a handful of these things, right? Training and experience, maybe some literature, da 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 da, right? And so if we know kind of what the battlefield looks like before we ever step in, right, through that designation, through preparing with the attorney, then the physician or the expert witness should be good to go. And now also there's nothing wrong with, listen, that's outside of the scope of what I've been retained for as an answer, right?
Okay.
You're asking me questions that I just don't know the answer to, and I would need this information in order to have an opinion on that. So at the end of the day, we never want to be in a situation, just like when you're doing your work in the hospital, right? You never want to be guessing, right? Or at least be making just wild guesses. They need to be you're being asked questions and you're being asked to answer those questions under oath to the best of your ability. And if you can't do that, then say so. And I mean, there's nothing wrong with that. And I don't know is fine. This is not what I was prepared to testify for is fine. Or I mean, all that stuff is fine. So coming back to the short answer would be just make sure it's clear between you and the attorney exactly what you're being called to testify for.
That makes sense. Like I could be an expert in emergency medicine, but if somebody asks me something about, you know, neurology that's outside the scope of emergency medicine, just say I don't know. Um,
Yeah, let me actually
sorry.
give you a quick example that I think will help
That'd be great.
clarify this. So, in Virginia courts, we have to qualify our experts. And so, oftentimes, what you'll see at the beginning of any sort of witness examination when we're dealing with a physician, and actually, I'll reference the one I did the other week, where we did an orthopedic surgeon who was the one who conducted the surgery on our client at the very beginning, I like to do the big outline. I like to say, were you the treating surgeon in this case? Yes, I was. Okay. Can you help us understand the injuries? Yes. Can you help us understand how it impacted the client? Yes. Can you help us understand whatever? Yes. Okay. Why are you the right person to help us understand all of those things I just mentioned? Well, I've been treating patients for years, handled thousands and thousands of cases. I went to school here, there for decades, right? I've done all these sort of this residency, all these fellowships, all that. And of course, I treated the client. At that point, the lawyer, before being able to get any sort of expert testimony, has to qualify the expert. So at that point, for example, in the situation of an orthopedic surgeon, I would say, Judge, at this time, the plaintiff moves to qualify Dr. whoever it is as an expert witness in orthopedic injuries concerning the hip and knee. It may not have to be that specific, but so now the scope is clear. This is not an expert in anything. This is an expert just in those specific orthopedic injuries. Does that answer the question?
Yeah, that helps a lot. As somebody who's not been through this, it's a big unknown. You know, I want to provide good testimony and I want to do it under the correct scope. And so that helps.
Sharif, having gone through all this, can you talk a little bit about what makes effective testimony for a physician who's been subpoenaed and is there in the chair?
Absolutely. So effective testimony is a product of preparation, like anything in life, right? Uh, at the end of the day, our job in the courtroom as lawyers, and I believe also as witnesses, is to teach. It's to teach the jury, teach the judge about what happened, to help guide the fact finder to the right decision. And so What I like to help my witnesses do is embody and embrace that teacher mentality. And that means I'll look at the jury and I'll explain and I'll ask the witness to look at the jury with me. And I'll ask the witness to explain this stuff. Okay, well, what does that mean? You just use this fancy medical term like, what is that thing? Is that this in the arm? Yeah, okay. Well, tell us how that works. A very, very good tool that I highly recommend. And not only does it help the fact finder understand this information, but it also helps, I think, with the delivery of it and the preparation is the use of visuals. So, I mean, if you can bring in a model, right, to say this is how the body part worked and this is what we did, or if you can show pictures, right, and all this stuff is stuff you're going to do in advance when preparing with the attorney. But if you can adopt the mindset that your job is not there to advocate, you're not there to win the case, you're not there to to make the other side lose. You're there is to convey the information that's being asked of you, right? And so if you can prepare yourself to convey that information in a way that educates everyone in the courtroom, then you've done a hell of a job.
I like that point. You're not there to
Yeah,
win or lose a case.
I like
Just,
that.
you're kind of educating everybody.
And we have to tell our clients that all the time, right? I mean, our clients, when they want to testify, they want to be advocates. Like, no, your job isn't to advocate. That's my job. You hired me to be your advocate. Your job is to answer questions that are asked of you and provide the truth, right? And we'll ultimately trust the jury to come to the right result.
You don't know what you don't know. So, Sharif, what are the biggest pitfalls or mistakes that we haven't discussed that you've seen physicians make either before they get to the deposition or courtroom or in the courtroom? What other, pearls do you have for us?
Yeah, I'll tell you the times that I've seen doctors not do well in the courtroom is when they're not prepared. It's when they haven't reviewed the charts or they don't really have a good grasp of what is being asked of them, what their role in the case is. And that's just it's not good for the doctor. It's not good for the patient, the client, or our client. And it's just not good for the process of trying to get to the truth, right? So being prepared solves almost every issue there could possibly be. So, and when there's any doubt or any ambiguity beforehand, ask. Like, say, hey, we need to take some time and prepare. Like, I need to know, I still am unsure of like what you're going to ask me, right? And what I'm going to be expected to deliver. So it comes back, I guess, full circle in some respects. It's communication. Don't be afraid to pick up the phone and talk to the attorney and say, hey, what do you need of me? How can I help? Right? Like, and then it all goes just so much easier.
That makes a lot of sense.
Well, Dr. Spangler, Sharif, thank you for joining us today, and thank you all for listening on. We hope today's VACEP Presents was helpful, and stay tuned for our next one. Thanks again for joining.